esteemed colleagues, Mr. Professor Ada János Szilágyi, thank you very much for the invitation to be here with you, to be together again here in Budapest, and to give me the opportunity to speak about this purposivism and consequentialism in assessing the rule of law in Romania, the Court of Justice approach. So it may seem that the title is very strange for us, but I will try to explain it better in the following slides. So in my presentation, I began with a work of a former American judge, member of the Supreme Court of Justice between 1986 and 2006, Justice Scalia, who wrote a very interesting book on reading the law. You know that Scalia was an originalist as concerns the interpretation of the Constitution, and a textualist when it comes of the interpretation of legal norms, so infra-constitutional norms. When we are speaking about textualism, it means that we have in mind only the text, only the semantic understanding of that text. We do not try to determine purposes, consequences of that text. For example, Scalia rejects judicial speculation about both the drafter's extra-textually derived purposes and the desirability of the fair reading's anticipated consequences. He sees all these as, so he sees that if you are an adept of purposivism, you are a kind of adept of manipulation of the text. He gives us an example, the stop sign story. The example is the following. You have a rule in which says that whenever you have the stop sign, you have to stop the car, not to go, or to, let's say, to go slower. And the example is the following. A person at 3 a.m. sees this stop sign and doesn't stop, but decreases the speed of his car, makes left, right, nothing is coming, and goes with the car. The police stops that person and says, okay, this is a contravention, this is an offense, and I have to fine you. But when it comes about judicial evaluation, assessment, the judge says, okay, but it was 3 a.m. and when it's 3 a.m. there were no cars, no people, so it was no public interest to, or public safety. It was not a question of public safety. So I admit the action of the party and says no contravention. Scalia sees this as a danger, because it seems that you are not in the text, you are not textualist, but you see the purpose of the text. Non-textualism frees the judge from interpretative scruple. Non-textualist favorite substitute for text is purpose. It's Scalia. Purpose of the author means that all sorts of non-textual material, such as legislative history, becomes relevant to revise the various objective meaning of the text. He sees that, as I've told you, the most destructive feature of purposivism is its manipulability. So it's a kind of manipulation of the text. It's a kind of rewriting the text. The other orientation that is criticized by Scalia is consequentialism. He sees consequentialism as pragmatism or workability. He sees consequentialism as purposivism too, as a mask of judicial lawmaking. The purposivist and the consequentialist go beyond the immediate purpose or consequences that are evident from the semantic understanding of the text, and they try to find another purpose or other consequences. And often these consequences and purposes are abstract one, and these are a kind of purposes, consequences established by the judge and not by the text. So Scalia sees this as dangers for the courts to adopt an interpretation in consideration of a purpose or the consequences that may arise. And I will try now, maybe as I've told you, as I've told somebody, that our relationship with the EU law, it become in the last years a kind of fashion. A fashion for Romania because I think we had 6 decisions against, let's say, Romania. But it is not very wise to say against Romania, decisions that concerned Romania, because the problems arised in those decisions are common to the whole European space. As you know, the rule of law, and our colleague told us before, is comprised in Article 2 of the Treaty of the European Union. In 2 judgments from 2021, the first one is C83 per 2019, and the second one is 357 per 2019, says that this Article 2 constitutes a precondition for the accession to the European Union of any European state, of course, peculiarly to Romania. It is in that context that the cooperation and verification mechanism was established by decision number in order to ensure that the value of the rule of law is complied with in Romania. As our colleague Mr. Ahmed Veres told us, this decision established 4 benchmarks, and the benchmarks were a very pretty abstract one. I emphasize there that in those 2 decisions, the ECJ repeated in the operative part of the decisions that the benchmarks are intended to ensure that Romania complies with the value of the rule of law. It is pretty uncommon that in 2 consecutive decisions that concerns a certain country to appear in the operative part a phrase, an identical phrase. So identically, because maybe the ECJ had in mind that the Romanians didn't understand very well the first decision. And maybe the ECJ was right, because between the 2 decisions there was a very controversial Constitutional Court decision. These are the benchmarks, and please pay attention to benchmarks number 1, number 3, and number 4. Number 3. Building on progress already made, continue to conduct professional, non-partisan investigation into allegations of high-level corruption. This is a kind of policy, not an obligation to a certain court, to a certain person, to certain prosecutor offices. And, of course, pay attention to the first conditionality too. It envisages the question of judicial system. Okay. What I want here to emphasize on textualism and purposivism and consequentialism is that the ECJ, in the decision from 18 May of 2021, says that it is apparent from recital number 6 that decision and from the particularly broad wording of the first, third, and fourth benchmarks set out the annex of the annex of that decision, and as confirmed by the Commission report, decision number encompasses the judicial system in Romania as a whole and the fight against corruption in that member state. So actually, it is not a kind of semantic interpretation of the text, of textualism, but it is a kind of purpose. You have in mind a certain purpose. to encompass the whole judicial system in benchmark number 1. That benchmark goes back. It is not about the whole judicial system. It was the decision is from 2006, and in 2006, 7, 8, 9, and especially in 2009, Romania adopted new civil code, criminal code, civil procedure code, and criminal procedure code. So that was the rationale at that moment of that number 1 point, number 1 benchmark. But as I try to point out, is that through interpretation, you give another understanding of that very narrow text. The ECJ decision from May 2021. It's about, again, rule of law. I think that in every member state, there is a judicial body responsible for conducting disciplinary investigation. And what was the point here? You have an ordinary procedure to appoint the person who coordinates this unit, this judicial body responsible for disciplinary investigations. But in 2018, the government adopted an emergency ordinance in which for 6 months made a special procedure, because in that context of reforms, there were no time to proceed on the ordinary procedure to appoint persons as chief of this judicial body. And the ECJ says no, such kind of conduct from the government, from the legislator of Romania, is in breach with the rule of law. What I want to mean is that when you have this rule of law, via interpretation, you link a lot of consequences to this. You have the rule of law. You are not allowed to make a derogatory procedure to appoint a certain chief of a judicial body that conducts disciplinary investigations against judges and prosecutors. In that decision too, as I've told you last time in October, I was speaking about a special unit that investigates criminal offenses committed by prosecutors and judges. Corruption matters. First of all, I have to point out that all these matters, all these investigations, were conducted by a special unit, National Anti-Corruption Directorate, Ratione Materie. And in 2018, the legislator took a part of this of the competence of this anti-corruption unit and established on another unit only for judges and prosecutors. And it seems that rule of law, not it seems, rule of law is against this kind of legislative behavior. So all kind of special units that are made have to be made, let's say, as a rule after ratione materie, and only exceptionally ratione personae. And this legislative measure didn't meet the requirements of the rule of law. Please note, on the left side, I put it, that the ECJ says the creation of such a section falls within the first, third, and fourth benchmarks set out in the decision 2006 per 928. So this decision in 2006 had mostly an economic value on the internal market, but it was extended, let's say, on what it means investigating criminal offenses too. So, as I goes back and I point out that when it comes about judicial body responsible for conducting disciplinary conduct, for special units of prosecutors that investigates crimes committed by judges and prosecutors, falls within the rule of law, And here it is an interesting question about constitutional courts. As you may know that in principle the constitutional courts are independent and impartial. But the ECJ in this decision from 2021 analyzed if the Constitutional Court of Romania was indeed independent when it analyzed certain unconstitutionality requests. And please pay attention to the right side on the white side. The court says the requests for a preliminary ruling do not contain any detailed information from which it is apparent that those decisions were made in a context giving rise to a reasonable doubt to the complete compliance of the Constitutional Court with those requirements, independence and impartiality. So that means that in the future, on the basis of rule of law, it seems that the ECJ has the competence to analyze if a constitutional court was indeed independent and impartial when analyzed certain provisions and declared them unconstitutional or not. So it seems like rule of law gave a super competence of the ECJ toward national infra-constitutional legislation, but for constitutional legislation too. You may ask yourself that this principle, as Nico said, it is an abstract one, so it is not defined anywhere, because via interpretation you will put in under the umbrella of this principle various requirements, various problems, questions. In another decision from February 2022, the ECJ was more cautious when applied Article 3, the rule of law, against Romania. As you may have seen, it was a question of the preliminary ruling. If a court can make a preliminary reference to the ECJ, if the Constitutional Court previously stated that the law is in line with the if the law is in line with the European acts, mandatory acts. Okay, the Constitutional Court, I think, a bit overstepped its competence, but however, in this specific case, the ECJ states that the core article is Article 19 that concerns the competence of the ECJ, and this article has to be read in conjunction with the rule of law. So you do not have anymore, as at the previous slide, for example, that Article 2 has to be interpreted in a certain manner. It is Article 19 read in conjunction with Article 2. Here is I think it is my last slide. It is maybe a bit complicated, but I will try to explain it. Statute of limitation. For example, a person made a crime of corruption. That crime, it is investigated by the prosecutor. According to the law, you have a statute of limitation, let's say, of 5 years. In the Romanian law, if you investigated all these, these 5 years of limitation, you may have another 5 years extension. So a corruption, let's say crime, could be investigated in a period composed of 5 plus 5 years, 10 years. In the first decision, the Constitutional Court said that it is unconstitutional to prolong this statute of limitation with the other 5 years, as long as you can prolong it by making investigated acts that are not communicated to the accused. Taking into account this decision, the courts said, okay, if we communicate any procedural act to the accused, we get an extra 5 years, 5 plus 5. But in 2022, the Constitutional Court said, Court, you understand wrongly my first decision. I gave you only an example of political legislation, legislative action, that the legislator may come and say that if you communicate, everything is okay. But because the legislature didn't come with such a legislative solution, you are not able to prolong with another 5 years this statute of limitation. So the problem was that in the Romanian criminal law system, the statute of limitation is a substantive criminal institution, so it applies retroactively. Example, if you have these 5 years before 2018, because you have to apply it retroactively, it applied to criminal offenses committed, let's say, in 2013 plus 5 years, 18 before this decision, and the trial has to be terminated, stop. And the Supreme Court, in a decision on point of law, followed this problem and said, meteor lex, you apply it retroactively. And in 2 cases, the ECJ in 2023 and in January 24 said, no, I cannot recognize the retroactive effect. And I will recognize only the pending effect of this decision. So if you have a certain crime committed in 2016, plus 5 years, 21, and for that applies the decision, so you cannot have this extra 5 years. The Court of Justice was speaking about the systemic risk of impunity. It is very difficult for a certain court to assess the systemic risk of impunity. But this is another discussion, and I won't enter into it. What I wanted to emphasize by this decision is that all these are linked with the rule of law. All these are linked with general principles that are not defined, are not pointed out exactly in the the EU law. So always you will have interpretations that have a kind of lawmaking sense, and lawmaking by establishing purposes, consequences. So I come back to what Scalia said, that because we are not faithful to textualism, we become more and more we wish to apply as judges the law as we want to attach diverse significance to certain concepts through purposivism and consequentialism. Thank you very much.